Good afternoon. Today's the 9th of July 2017. I'm Karen Harding, lawyer from Auckland, New Zealand. This is video 2 of today's date. I'm going to review with you our draft submissions for the Supreme Court, asking for leave to appeal a Court of Appeal decision relating to forfeited vessel Oyang 75 that my clients, I have 30 Indonesian foreign fishermen seeking leave to appeal. The application for appeal is actually only about 26 fishermen because the extra 4 fishermen came after the appeal case started, but they have been able to join in the proceedings should the Supreme Court grant us leave if we win the case. So I'm just going to go through with you what's going on, and the point of why I'm reading it is this is a draft. We had 22 pages when I dictated it. We've been editing it down over the weekend and got to 14 pages, and we need to cut it again to 10, and we just thought it would be helpful to do an overview and see if that inspires some more editing to go on, and just to get some feedback. So the introduction sets out what decision is being appealed, and we're appealing, as I said, the Court of Appeal decision dated the 15th of May 2017, which was a decision dealing with an appeal out of the High Court on the 18th of December 2015, which dealt with 2 appeals that came out of the District Court in relation to these matters in April 2015 and July 2015. The applicants seek leave to appeal to the Supreme Court in relation to the determination at paragraph 51 of the Court of Appeal judgment and seek for that to be set aside. The grounds of appeal have been set out in our notice of application for leave to appeal to the Supreme Court, which is dated the 12th of June 2017. Paragraphs 26, 28, 36, 37 to 39, 46 and 49 to 51 of the Court of Appeal judgment are at issue in this application for leave to appeal. I also then refer to the High Court judgment, which sets out the legal matters and set out what paragraphs I wish the Supreme Court to take particular notice of. And they relate to paragraphs 13 to 15, 33 to 38, 40 to 41 and 24 to 25. Section 74 subsection 2 of the Senior Courts Act 2016 sets out 3 criteria that must be met for the applicants to be able to establish grounds for leave to appeal. In an earlier draft we set out what that criteria was they needed to establish. We cut that to try to bring the page limit down, and we say in our submission that the applicants satisfy the criteria and seek determination as follows. The first determination we seek is that any fishing crew member, employee, may have an interest in unpaid wages against forfeited property, including a vessel previously in their employer's beneficial ownership, without having worked on the particular forfeited vessel. Secondly, that the determination of Justice Davidson at paragraph 63 of the High Court judgment was correct. The entitlement to an interest in unpaid wages extends to crew claiming relief against forfeiture under section 256 of the Fisheries Act against forfeited vessels, regardless of whether they worked on those vessels or not. And that the Court of Appeal erred at paragraph 37 of its judgment in its statutory interpretation approach of section 256 of the Act, subsection 1. When I talk about the Act, I'm talking about the Fisheries Act 1996. Section 2 sets out the relevant legislation at issue, which is section 256 of the Fisheries Act, and to keep things small rather than citing the section because there's just no space there because it's quite long, we simply say the Court of Appeal judgment sets out paragraph 12 and 13, section 2561 and section 2563. The High Court judgment considers the full section of section 256, setting out section 2561 to section 2568 of the Act after paragraph 43. There's no case law on these sections regarding wage claims over forfeited vessels. This is the first time that this issue has come before the courts in New Zealand. Section 3, background and the narrative of facts. The background facts are set out in the Court of Appeal judgment at paragraphs 1 to 8. The 26 applicants, that are Indonesian nationals, were employed between 15 December 2007 and the 20th of October 2011. Work permit conditions required the applicants to work exclusively for their employer on their fleet of vessels. The applicants' employment conditions met the International Labour Organisation's ILO definition for forced labour. The applicants face significant barriers to access justice due to lack of awareness of their rights, impoverishment, language barriers, and difficulty engaging counsel in another country. 30 employees from Oyang 70 and Oyang 77 have filed applications seeking relief under Section 256 of the Act, which we defined as the 256 process, claiming over Oyang 75, and collectively Oyang 77, 70 and 75 we refer to as the Oyang vessels. The other employees may also come forward to seek relief for their unpaid wages. The exploitation on the Oyang vessels generated public outrage, media coverage, ministerial inquiries, legislative and industry changes, to no judicial effect of restoring the forced labour victims their wages. The Section 256 process involves a unique New Zealand solution to ensure unpaid wages get paid from forfeited vessels vested in the Crown. This Act permits consideration of wage claims over forfeited property prior to disposal. The orders under Section 256 subsection 8 of the Act provides for forfeited vessels to be sold. The Court controls that process, balancing the power disparity between the employer and the employees. Section 4. The question of law and issues raised in this proposed appeal. Section 103 of the Act requires an owner of a registered foreign fishing vessel to pay their employees who worked on their vessels pursuant to the Minimum Wage Act 1983 for every hour worked. The owner was required to comply with the Wages Protection Act 1983, any other provisions of enactments necessary to give full effect to that Act and the Minimum Wages Act 1983 and the terms of the 206 Code of Practice for Foreign Fishing Crew. The Oyang Corporation was the foreign owner of 3 vessels involved in this matter and was their employer. The interest that fishing crew can have in Section 256 of the Act to claim over forfeited property is an interest pursuant to Section 256, subsection 1b, Roman numeral 2, in unpaid wages. The question is whether an employee can claim unpaid wages under Section 256 of the Act over a forfeited sister ship not worked on that had been in the beneficial ownership of their employer, a party liable to pay their wages immediately prior to forfeiture. There's 3 points there. A. Does an employee have to have worked on the particular forfeited vessel prior to forfeiture to assert an interest in their unpaid wages over it? B. Can a vessel owned by an employer immediately prior to forfeiture on which an employee did not work be defined as forfeit property or other forfeit property? Can an employee claim an equitable interest in their unpaid wages over other forfeit property in another forfeited fishing vessel, in this case the sister ship vessel Oyang 75, that they did not work on, as forfeited property pursuant to Section 256, subsection 1, round bracket little c, of the Act? The determination of the questions depends on the statutory interpretation of the words forfeit property and interest under Section 256, subsection 1 of the Act. Also at issue are the words other forfeit property and equitable interest in the forfeited property that existed at the time of forfeiture, pursuant to Section 2561, subsection C of the Act. Section 5, Statutory Interpretation, Section 256, subsection 1, the importance of context. Section 256, subsection 1 states, in this section, unless the context otherwise requires hyphen, forfeit property means any hyphen, end quote. Accordingly, the issue to be determined is whether the court can permit context to be used interpreting the terms forfeit property and other forfeit property in relation to the interest in unpaid wages. Justice Davidson provided a statutory interpretation applying context. He considered, can or should the crew members' inability to pursue a claim in rem against Oyang Corporation be brought to bear when interpretation of the term forfeit property in the Fisheries Act? Justice Davidson invoked as a statutory permit context for interpretation and cited authorities from other legislation permitting that approach. This was rejected by the Court of Appeal. However, a contextual approach is allowed for in Section 2561 of the Act and Section 4 of the Statutory Interpretations Act 1999. The Court must consider A. whether the statutory interpretation adopted by the Court of Appeal led to a substantial patent error that, left uncorrected, would be repugnant to justice to leave uncorrected. B. Any matters of general or public importance or general commercial significance or miscarriages of justice and the interests of justice. And C. Any error in statutory interpretation leading to an incorrect interpretation of Section 256, subsection 1 of the Act, leading to an incorrect determination of the ultimate result that may result in the appearance of a miscarriage of justice. The ultimate issue, the Court of Appeal judgment, is at 11, paragraph 11. This concerns whether the applicants who did not work on Oyang 75 can claim their unpaid wages over it as forfeit property. Section 6. Submissions on the grounds of general importance. Previous cases have held that general importance is directed at larger issues than just between the parties. Leave was declined in cases involving disputes over contractual arrangements where there were no issues of general or public importance or matters of general commercial significance, where matters at issue affected only the people in the dispute. The issues here, which is our submission, is distinguishable. They concern interpretation of a section of law that has not been between the courts. A large number of victims of forced labour applicants are affected, for which there is a public interest and a general importance in seeing that their minimum wages are paid. Migrant fisher exploitation is unacceptable. It is a statutory obligation and in the national interest to pay wages pursuant to the Minimum Wages Act 1983. Foreign employers with no assets in New Zealand are particularly difficult for an employee to deal with, as there's no means to enforce payment in New Zealand. Section 256 provides migrant fishers with access to justice to obtain wages from Crown assets, being the only trusty source for payment, when an order is made under Section 256 (7) of the Act for forfeit property to be sold. This application, which is the one for leave to appeal, is distinguishable from Junior Farms Limited versus Hampton Securities Limited in liquidation, a Supreme Court case 2006. Transpower New Zealand Limited versus Todd Energy Limited, Supreme Court case 2007. And Goff versus Goff Holdings Limited, Supreme Court case 2008, which concern matters only affecting particular people. Whereas here, there is a large class of exploited migrant fishers. 30 employees who applied under Section 256 have impoverished extended families. Their community was deprived of income. The abuse caused misery and outrage. The problem was widespread across the foreign fishing vessels, affecting the whole commercial fishing industry, obviously in New Zealand. How the courts respond to interpreting Section 2561 of the Act, which protects our most vulnerable fishers, as a measure of our humanity as a nation. Fishers are vulnerable to abuse and exploitation because of long periods at sea and the lack of oversight and control over labour practices due to remoteness. This occupation has one of the highest mortality rates in the world. In a quote, also, forced labour and human trafficking at sea must be understood in the context of a crime complex at sea involving, among others, fisheries crime and corruption. The link between forced labour, human trafficking and fisheries crime is emphasised in the literature. End quote. Identified fisheries crimes resulted in the forfeiture, and the Court of Appeal judgment stated, "There is no doubt that there are monies owing." Fishing operators brokers and recruitment agencies are able to use coercive and deceptive labour practices with migrant fishers where they are impoverished, inexperienced and naive. This makes them vulnerable to exploitation. This situation was not well monitored by New Zealand and resulted in these applicants, which is my 26 appellants here, becoming exploited and unpaid. There is a general importance in protecting the vulnerable and repairing the financial hardships caused to the hard-working applicants who have contributed to the New Zealand economy. Section 256 allows all these factors to be considered when forfeited property is to be disposed of. Subsection 256 (7) (f) requires the court to have regard to the social and economic effects of persons employed by the owner of the forfeited property. This subsection allows orders to be made to satisfy an interest in unpaid wages pursuant to section 256 (1) (b) Roman numerals 2 of the Act. The definition of forfeit property should not be restricted to just a forfeited vessel the employee has worked on. Fleets were used in fishing operations and the working circumstances and abuses of employees was identical across the fleet. Permitting employers to settle with crew from the high-value vessel who do not pay employees from low-value and lost vessels is an abuse of the redemption process. The Calibolt case, which involved the Russian fishermen, led to the Act, being the Fisheries Act, being amended. It also involved a fleet of foreign fishing vessels and over 100 crew. There was no process to permit the forfeited vessels to be sold to pay wages. The process under the Admiralty Act was slow, difficult and caused public outrage at the fishers' circumstances. It affected the industry, leading to national change, including the creation of the Section 256 process. Public policy demands context be considered. The approach of Justice Davidson being the appropriate statutory interpretation of Section 256 subsection 1 of the Act regarding the terms forfeited property as held in paragraphs 57 to 60 and 63 of the High Court judgment. Accordingly, there are matters of general importance that this court should hear and determine. Subsection 7. Submissions on public importance grounds. There has been concern in national and international media about the treatment and underpayment of migrant fishers on foreign fishing vessels, including the treatment of fishers on the Oyang fleet of vessels. The treatment of the fishers caused public outrage, with New Zealand becoming a destination for human trafficking in fishers, downgrading New Zealand's international reputation. The exploitation on the Oyang vessels was a form of modern-day slavery. It was degrading for the applicants and dirtied the supply chain of seafood goods marketed as the produce of New Zealand. It is estimated 61,000 Indonesian migrant workers were affected by forced labour issues, including minimum wage abuse in New Zealand. It is extremely difficult for exploited migrant fishers to access the courts. Subsection 8. Miscarriage of justice matters, and I'm saying the miscarriage of justice may occur if leave is not granted. And the submissions go, unlike in Junior Farms Limited versus Hampton Limited in liquidation case, that acknowledged no principle of law or general public importance in their application, this case includes principles of law and of general public importance. Say your Oyang Corporation's activities caused abuses of vulnerable migrant fishers, breaches of the Minimum Wages Act 1983, and ramifications to the commercial fishing industry, including deaths of its employees. For the applicants, my clients number 14 and 15, it is almost a decade since they commenced employment, and they are still unpaid. The lack of willingness to pay minimum wages undermines New Zealand's values, principles and law. The abuses demonstrate a general failure of a foreign employer to respect the dignity of their third world employees. It is up to the court to act to ensure payment under the Section 256 process. Section 256 subsection 1 of the Act enables this court to apply the correct statutory interpretation applying context as in the High Court judgment. This empowers the courts under Section 256 (7) to order the payment from forfeited property, including Oyang 75. Furthermore, this case has bearing on New Zealand's international relationships with its Indonesian trading partner, who demands better treatment of its workers, including the payment of wages. This matter can be distinguished from civil appeals that have been declined leave to appeal, as it is a rare case. The questions of fact, law and apparent error are substantial. It would be repugnant to justice if leave was not granted. This case involves matters of general and public importance and general commercial significance to the maritime industry. Section 9. Submissions on general commercial significance. This court has not granted leave to appeal in cases where issues only have commercial significance to parties involved in the particular interpretation and or enforcement of unique contractual arrangements that do not give rise to any larger issues in respect of which this court can give guidance to other litigants in the future cases. And the example I give in the footnote is Shell Petroleum Mining Co Limited versus Todd Petroleum Mining Limited 2008, a New Zealand Supreme Court at 26. In the footnote I say that where the particular dispute had no element of public importance, had no patent or significant errors to give rise to a miscarriage of justice, in the context of a civil appeal where there was little prospects of success. Going back to my submission, this case is distinguishable due to the element of public importance. There is a prospect of success on appeal. There is a precedent value because it defines important words in Section 256(1) of the Act. A correct determination will also guide this case through 8 subsections of the Act. Many iwi granted quota under the Sea Lord's deal could not afford to buy vessels and contracted out their quota. Foreign fishing vessels chartered by New Zealand companies to catch quota that was allocated to Maori under the Treaty of Waitangi settlement marketed their catch as produce of New Zealand. Recruiting migrant workers pursuant to an authority in principle to recruit an AIP to work on foreign fishing vessels to fish quota had significant commercial impact, contributing, for example, in 2011, $30 million to the economy. And then I've got a quote: "Workers are fishing in rusty boats turned into high-sea sweatshops that take parts of the country's $1.4 billion a year catch." The Indonesian government demanded action to crack down on slave ships to remedy the plight of its fishers. The Oyang Corporation's commercial venture in New Zealand with its fleet caused ongoing consequences over a decade, affecting our natural resources, damaging international trade relations, creating a dirty supply chain involving human trafficking, Fisheries Act offences, and the commercial culture that valued profit at the cost of human rights abuses on vessels. It is practically impossible for impoverished victims to make in-ring claims over redeemed vessels released out of the jurisdiction by the Ministry of Primary Industries. They could never pay fees or port disbursements to arrest the vessels. The interpretation of forfeit property in the Court of Appeal judgment fails to consider all relevant considerations. Commerce cannot take place at sea without a trusty source for wages. The courts must allow for the applicant's wages to be paid out of the employer's forfeited property under the Section 256 process, otherwise an appearance of a miscarriage of justice is created. There are Crown assets forced labour victims should be paid from. Denying this claim results in a windfall profit of at least New Zealand $10 million to the Ministry of Primary Industries at the expense of victims. If Oyang 75 was redeemed by the sale Oyang Corporation, who created these issues and who does not pay its crew, the state rewards them, allowing unjust profits from failures to comply with the Minimum Wages Act 1983. The unjust profiteering, as correctly analysed by Justice Davidson, goes against the rule of law when Section 256 subsection 1 is interpreted in its proper context. 10. Concluding submissions on why leave to appeal should be granted. It is in the interest of justice for the court to grant leave to appeal. There are questions of law raised. The appeal concerns no issue of settled law. The matter is of great importance to a large number of applicants. There is public interest in ensuring minimum wages are paid. The media continue to update the public on the fate of the Oyang crews. The applicants have interest in unpaid wages being an equitable interest in forfeited property Oyang 75 regardless of not working on it. Section 256 subsection 1 subsection C allows the court to consider an equitable interest in the case of other forfeit property which can be another forfeited vessel that belonged to the employer. It is referred to in Section 256 subsection 1 subsection B subsect Roman numerals 2 that the interest in wages is an equitable interest that includes a foreign vessel. The applicants are indisputably fishing crew. That was something in the act there, who have unpaid wages, thus they have an equitable interest in the property belonging to their employer before forfeiture. It was not intended that Section 256 of the Act restrict a wage claim for relief only to matters set out in paragraphs 1.8 D.I. to 4 of the applicant's notice. I've got quite a bit of stuff going on the notice of the application for leave to appeal, and to cut space down I've just referred to that section in their submissions. Justice Davidson approach is most accurate in law and balanced in every appropriate consideration. It provides the relevance of context and interpretation with supporting authority, giving effect to Parliament's intention that unpaid wages be fully considered when forfeit property is for disposal, whether or not the crew member worked on the particular forfeited vessel. The Court of Appeal judgment failed to consider all relevant public interests, public importance and public policy considerations to statutory interpretation. It is interpreted and analysed legislation creating an appearance of a substantial miscarriage of justice warranting leave to appeal. This court, i.e. the Supreme Court, should correctly interpret the law and avoid a substantial miscarriage of justice. If the criteria in Section 74 round brackets 2 of the Senior Courts Act is not satisfied, it is submitted that it will still be necessary in the interest of justice for this court to grant leave, given the stated criteria in Section 74 subsection 2 is not all embracing, as Section 74 subsection 5 of the Senior Courts Act states that Section 74 subsection 2 does not limit the generality of Section 74 subsection 1. Section 11, final section. Submissions on costs and preferred date for hearing. No costs should be awarded against the applicants. The applicants do not have any funds to pay costs due to unpaid wages. This matter is pursued due to the matter of principle involved, and that was accepted in the Court of Appeal judgment. In the case of Basil v. Atwell, Court of Appeal decision from 1995, no costs were awarded where the appeal was advanced due to issues of principle involved and by way of a test case. The applicants will also apply for a waiver of security of costs. The applicants were not required to pay security of costs at the High Court, and leave is sought to file further submissions on this point and any other issue that may assist the court to resolve matters. And then I just have a brief list of 3 lines of dates that aren't suitable to me as counsel to appear in Wellington. Dated this 9th day of July 2017. Counsel for the applicants, Karen Harding. So that was our draft, and now I've got to edit that down another 4 pages. Hope you found that interesting.